New Zealand Crown Solicitor Ben Vanderkolk has got himself in trouble. He was ordered to pay half of a $40,000 fine imposed by the High Court. Vanderkolk was fined because he conspired with a member of the New Zealand Police to conceal his own and his legal junior's attendance at a prison meeting with a jailhouse snitch. Vanderkolk's victims were defendants in a botched murder investigation and failed Crown prosecution. This is the first time in New Zealand's legal history that a Crown prosecutor has been fined by the court under Section 364 of the Criminal Procedure Act. He will have the dubious distinction of being the namesake for what going forward will undoubtedly be cited as Vanderkolk damages. Issues with the veracity and reliability of evidence from jailhouse snitches are well known in criminal justice circles. When the snitch has been given inducements, as was the case here, there is a high motivation for them to lie. We are disappointingly familiar with members of the New Zealand Police fabricating and withholding evidence and lying in court. Our legal history is littered with cases like Tiana Pora, Alan Hall and David Little. Police officers, though, are by and large just unskilled labourers indoctrinated into a peculiar amoral ideology, so we probably shouldn't have high expectations of their ethical standards. But Crown solicitors are not police officers. They are not undergraduates who have never heard of Bentham or Kant. They are lawyers and officers of the court. They have professional ethical duties and an obligation in their role to be ministers of justice. The court relies on the honesty, candour and integrity of Crown solicitors, but Vanderkolk's case proves that Crown solicitors cannot always be relied on to be honest and candid, or to act with integrity. The cost of Vanderkolk's conspiracy is confined not just to his damages. There is also estimated to be a couple of $1 million of taxpayers' money spent on a botched police investigation, a failed prosecution, substantial legal aid fees, criminal justice resourcing, and wasted judicial time. The most concerning aspect is not the cost, though. We still have a murderer walking free amongst us. He or she could strike again at any time. Any one of us could be the next homicide victim. This case comes after another case in which Christchurch-based Crown Solicitor Pip Curry was fined and censured for failing to disclose inducements received by a snitch, giving evidence in a case that she was involved in. In other words, she failed to disclose exactly the same type of evidence as Vanderkolk did. There is concern that the amoral, win-at-all-costs ideology of the New Zealand Police has infected and afflicted the Crown Prosecution Agency. The same ideology has seen Vanderkolk respond to the fine with a propaganda statement, completely devoid of any apology or any sign of remorse. Vanderkolk's arrogance and complete lack of insight is indeed breathtaking. Curry was fined $500. That contrasts sharply with the $20,000 fine imposed on Vanderkolk. It sheds light on just how serious Vanderkolk's conspiracy really was. In fact, Vanderkolk's conspiracy was arguably a criminal offence under Section 117 of the Crimes Act. Hopefully Vanderkolk is the catalyst for change, an overdue Me Too moment in our criminal justice regime. It's high time to cull the narcissistic, parasitic shysters who wallow in the criminal justice cesspool, enriching themselves at the expense of hard-pressed taxpayers and the misfortune of potentially innocent defendants. Vanderkolk's future is uncertain, but there is one thing of which he can be sure. Today, it is my civic duty to announce that Crown Solicitor Ben Vanderkolk is hereby cancelled.